Thank you for being here. I'd like to welcome everyone here and also those watching online to the Commission's, I believe, first staff workshop on the ex parte process. I think this is actually a terrific use for a rainy Washington morning. Before introducing those at the table with me, I want to thank Pete Belvin to say that Pete has been instrumental in establishing this workshop would be a gross understatement. So thank you, Pete. With me as moderators are Mary Beth Richards, Special Counsel to the Chairman for Reform, and Associate General Counsel and Chief of our Administrative Law Division, Joel Kaufman. I'm going to ask Mary Beth to start us off by putting this workshop into the context of the FCC's broader reform agenda.
So thank you. Good morning, everyone. The reform agenda's goal is to make the FCC a model of excellence, and the principles are data-driven, transparent, timely, and efficient and effective decision-making. And this workshop today is to examine the rules and really feeds into both the timeliness and the efficiency prongs of that agenda, and I'm delighted to be a part of it.
And to give us an introduction to the work we'll try to do this morning, Joel Kaufman.
Thank you. In adopting the current ex parte rules in 1997, the Commission sought to provide participants in FCC proceedings, as well as the broader public, with a record of the information ideas presented in Commission proceedings. The ex parte rules sought to strike an appropriate balance, protecting procedural fairness and transparency on one hand, while encouraging the free exchange of information and administrative efficiency on the other. 12 years later, these objectives remain the same. However, our experience with the ex parte rules suggests that it may be time to consider whether stricter enforcement and/or amendments to our ex parte rules are needed to better achieve the objectives of the rules. In recent months, Commission staff has reviewed the existing rules, focusing how they work in practice as well as in theory. As we have examined the rules, 5 main groups of issues have arisen. The first group of issues centers on the recurring question of how to best assure the accuracy and completeness of information presented in written summaries of ex parte presentations. Specifically, how do we make certain that written summaries of oral presentations to decision makers adequately summarize the substance of the presentations and don't merely list the subjects discussed? Despite our attempts to emphasize this requirement in Commission orders and public notices, as well as on our web page, the concern remains that some summaries do not adequately disclose all new facts and arguments presented. To the extent this occurs, the objectives of procedural fairness and openness are shortchanged. There remains the issue of how to better achieve these objectives without unduly hampering administrative efficiency. One approach might be to require that a summary be filed for every ex parte meeting, whether or not new information was presented, although the summary of a meeting merely reiterating prior written filings could simply cite those filings. Others might argue for an approach in which staff would review every ex parte summary for completeness. Even then, the objectives of the rules could still be frustrated by the fact that staff evaluations of the adequacy of written summaries might unavoidably vary. In addition, the staff resources demanded by this approach could also take a serious toll on the ability of the Commission to do its work expeditiously. The second group of issues involves whether we should modify the list of exempt presentations, those for which the ex parte prohibitions are either relaxed or removed. For example, should the exemption that allows settlement discussions to occur be more narrowly defined to exclude certain types of proceedings, such as rulemakings? On the other hand, should some exemptions be broadened even if it reduces transparency to some extent, as in the case of contacts between government entities working on a common problem, even if they do not share jurisdiction over that problem? A third group of issues involves the sunshine period. For example, does the exemption still serve its original purpose of giving the Commission a week of repose before a Commission meeting? Further, assuming that we conclude that the exemption continues to serve a useful purpose, should it continue to apply to both oral and written presentations, including those filed electronically? Also, should the exemptions to the sunshine period be recrafted to prohibit a party from fishing for an invitation to make a presentation during the sunshine period? Or should it be amended to allow for replies to such exempt comments? A fourth group of issues is whether transparency would be enhanced if we required entities appearing before the Commission to disclose who owns a significant stake in them or contributes a sizable proportion of their budget. A final set of issues has rather suddenly appeared on our radar screen in the last few months, namely how the agency can use new media, such as blogs, to enhance access to government while still complying with the ex parte rules in the Administrative Procedure Act. These issues present a number of novel questions. For example, should blog postings be incorporated into the Commission's electronic filing system or maintained as a separate part of the record? How can we reconcile the desire not to artificially cut off blog conversations with the Commission's sunshine period, which generally prohibits presentations immediately before and after a Commission meeting? Finally, there are a host of issues pertaining to anonymous blog postings. Should they be made part of the record? If so, is the Commission required to respond to them? Blogs are the newest and potentially a very user-friendly form of public participation and information exchange. For that reason, the Commission has been taking a lead role among federal regulatory agencies in considering how to craft workable rules to incorporate new media into our decision-making process. We are testing some approaches in the Open Internet NPRM and in the Broadband NOI, but we realize that certain issues will become even more complex if we were to make blogs and other new media vehicles available in increasing numbers of proceedings. To give just one example, how can we assure that blog postings by members of the public who may not know much about Commission dockets be assured of finding their way into the record of the right matter? I have outlined some of the issues that we are considering in the context of improving our ex parte rules in practice. We will now listen to our panelists' views and suggestions.
That's a lot. It sounds like we better get going here. Let me introduce our panel. Starting at my right, Chris Bjornson, who represents the Federal Communications Bar Association's Access to Government Committee. He's an attorney with Steptoe & Johnson, representing cable and satellite clients. I understand you're also recently married. So congratulations from all of us to both of you. Diane Cornell is Vice President of Government Affairs for Inmarsat. She's past president of the SCBA, and during her FCC career served as counsel to 3 FCC commissioners. Jane Mago is former FCC General Counsel and the current Executive Vice President and General Counsel of the National Association of Broadcasters. Amy Melman is President of Melman Capital Strategies. That's capital with an O, not an A. A public policy advocacy firm representing clients before Congress and the FCC. Moving over to my left, John Milletta is CEO of M2Z Networks, which seeks to provide national wireless broadband service. Among his previous positions, he served as chief of the FCC's Wireless Bureau. Jeff Perlman is Attorney with Public Knowledge, a public policy advocacy group that promotes the public interest in access to information, especially on the Internet. Andy Schwartzman is President and CEO of Media Access Project, a nonprofit public interest law firm and advocacy organization promoting the availability of diverse information and ideas in the mass media. And finally, David Solomon is partner at the law firm of Wilkinson, Barker Nauer. David was formerly Deputy General Counsel here at the FCC and the founding chief of the FCC's Enforcement Bureau. On behalf of the Commission, thank you all for being here and taking the time. Let me start off by asking the first question. Jane, Joel has talked about some of the purposes that the ex parte contact system here at the Commission serves, and could you give your perspective on the goals that we're trying to further through these contacts, and I suppose whether or not they succeed in doing that?
Okay. Let me just say up front that I really am a fan of the FCC's ex parte rules. Mary Beth, I think in your comments a minute ago you said that part of the process here is to make the FCC a model agency, and I think the FCC's ex parte rules in a lot of ways are a model for other agencies to follow. Some of the purposes that I see the rules as providing is the kind of transparency that we're trying to engender throughout government by having a real record of some of the contacts that are made between individuals and government officials, but also to do it in a very practical way, to allow for real conversations to take place between outside parties and the government officials, so that you can have the kind of give and take that leads to better government, but also gives you the kind of record that you need so that it's fair to all of the parties that come before the agency. I think there has that fundamental fairness element of making sure that all of those who are participating in the proceedings have the opportunity to know what in fact is going on and how the conversations are going is a key element of the ex parte rules. I think that the rules do provide for that meaningful information from the presenter's perspective. They allow the presenter to have an official record of what they have said to the Commission, which gives them an opportunity to have that be relied upon by the Commission. From the Commission's perspective, it gives the kind of transparency that is important to this process and also does allow them to have some reliance on the presentations that are made. And from other parties' perspective, it gives them knowledge that the contacts have been made, and it gives them the ability to come in and make their own arguments.
Just reminded me of something my mother used to say to my brother and me, which was when everybody's wrong but Henry, we begin to look at Henry. And the FCC is an outlier. If our system is so good, and I think I'll direct this to David, and I want to be clear that within the bounds of civility, please jump in at any time. But David, we are very unusual in the degree to which the Commission allows, encourages, and permits the contacts themselves, apart from the reporting issues that we'll get to in a second. Do you agree that the ex parte system we have is a good thing, and do you have any explanation for why it is that the FCC may have evolved in a different direction than other federal agencies, including other independent multi-member agencies?
Sure. I mean, first let me actually congratulate you. I think as someone who worked a little on the ex parte rules, the concept that you got 10 of us to talk about the ex parte rules and an audience to listen is very impressive. So it's a good thing as part of the effort to kind of improve the Commission's processes. There is a difference, and I think it's historical, and I'm not quite sure why, but I think that, and Jane mentioned this, if you go back to the fundamental purpose of the Commission's ex parte rules, one of them, the core purpose, was to make sure that things got on the record. And I think there was a history, the FCC, it was very much an agency that did things informally, and there are pros and cons to that approach, but I think historically it was an agency that felt comfortable having the sort of give and take and informal back and forth with people involved in the process so they could get information and sort of get it not just in a written form. And that led to some difficulties in court in the 70s in the rulemaking context, where in the HBO case, the court was concerned that the FCC was deciding on the basis of things that weren't in the record. So I think what the FCC tried to do, and it may have come from a different perspective than other agencies, is sort of accommodate the fact that historically it was an agency that felt it was useful to have an informal back and forth, both with the parties that it regulates and others who are interested in the area, public interest groups, et cetera, with the fact that under the APA it needed to have a record, it needed to make sure it decided things on the basis of the record. So in that sense, I think as the rules have evolved over the last 30 years, since those court decisions, the FCC really has done a good job in improving its posture, making sure that things are, by and large, in the record, and certainly that things that it is relying on in its decisions are in the record. I'm sure there's always room for improvement, and it's a good thing to be thinking about that. But I think fundamentally it has achieved what the FCC set out to do, which is to ensure that there's fairness and that there's a record for its decisions that includes what people have said to it.
Is there anyone at the table who'd like to take the contrary view that we should be operating more like a court, that we should be more focused on paper pleadings, limiting the substantive comments to a comment cycle, and discouraging the sort of ex parte contacts on which the Commission has come to rely? Okay.
If I can
Yeah, please.
I think the problem with that approach is that it sort of disregards sort of the political nature of what goes on the inside the Commission in terms of the commissioners making the decisions. I think part of the problem is that you essentially have the staff works on things for a long period of time, and then in sort of a very narrow window of time, usually, especially on agenda items, other commissioners sort of have to weigh in, and what part of the ex parte contacts are designed to do is to allow people to sort of independently verify the record, independently verify positions that people might have taken into the item that's been drafted. So I don't think you can completely go to a court-style solution. I do think what we have to do is actually for the Commission to be very clear about that it's getting ready to make a decision so people become aware and sort of spend their time and effort trying to clarify the record. When you don't know things are happening on the outside, you're sort of, all you see is to the extent that you can monitor, and this kind of goes to the blog postings and the new media, you're not aware of the sort of significance of these ex parte contacts and what issues are sort of being narrowed or expanded or being resolved. So I think what would really help in this process is to have a very clear delineation that the Commission is getting ready to make a decision about a particular issue, which allows then people to come in and make their relevant statements. So
let me, and did you?
Yeah, when we're talking about general purposes, I do want to observe one important element of the ex parte rules that I think has been overlooked a little bit in planning this. We all view this, and we're joking about it beforehand, as very much an insider's kind of process and very wonkish in nature. But in fact, the transparency function of the ex parte rule affects lots of people, and in particular affects the press. And I would think that, working press should be considered to be an important player in this process, and they serve as proxies for the public as a whole. And I would note that some issue has been raised about only interested parties should have standing to file complaints about violation of the ex parte rules. And I think that that's way off. I think anybody should have that right, including the working press. These are ex parte communications are certainly could be obtained under the Freedom of Information Act. It's illogical that something that's not exempt from the Freedom of Information Act, which gives standing to anybody, should limit standing. So I want to focus on the purpose of transparency generally, rather than just affecting interested parties.
You've anticipated the question I was going to ask John, and maybe you've given the answer, but no one at this table thinks that there is a problem with the general system and that we should go to more paper-based system. But those who are not at this table, who are not represented at this table, and those who aren't generally familiar with the FCC's process, aren't frequent players here, aren't sophisticated in the ways of the Commission, I would think it could be argued that for those persons, the ex parte system is less transparent than a more court-like paper record. And is that a problem, or is the answer that if we have a healthy system of disclosure, then the press and those who generally represent the interests of those groups will have access and will be able to convey the information?
I think that if you look at if you're a California-based entrepreneurial company with no Washington presence, I think the issue is you might read about it and find out from the press that activity is heating up, but then there goes the next step of how do I present my information in a way that's sort of decisionally relevant, right? So you can have people making blog postings, they could be sending email, but the issue is how is the staff or the decision makers interpreting this input and making it relevant for the record? How are they, if somebody is a Nobel Prize winner and sort of writes an economic treatise on a particular FCC decision but sends it as an email, does it count? So these are the kind of challenges I think that you have even under the whatever system you go through. I think what we need is some clarity about when is input relevant, how is the input interpreted, and how widely disseminated is the timeline.
So I'll take over with my questions. It seems that we have some consensus that the rules are good, but let's assume for a moment that they can be improved. And we've heard a little bit on this, but if we can just go around the table, David, we'll start with you since you were the last in the introduction. And let me know in a minute or less kind of the biggest problem and your solution for that problem, please.
I think the Commission ought to think about changing in a serious way the sunshine prohibition. The original purpose of the sunshine prohibition was to give the Commission a period of repose, and the concept was that in the last week before a meeting it didn't want to be bombarded with information, and it could basically, the commissioners could sit in their office with kind of no outside influences affecting them. And I think as a practical matter, there have been so many chips in that process that I think we end up getting more confused by what the exceptions are and who gets in and who doesn't and how, in the sense that right from the start, Congress actually passed a statute saying, well, Congress, of course, has to be exempt from the sunshine prohibition. So commissioners can get letters from members of Congress and calls from members of Congress. There's been more increase in use of the media, so there are ads in Com Daily during the sunshine period. There are open letters to the chairman that get into the media. So as a practical matter, the commissioners aren't deciding things in isolation. And given that that's the case, I wonder if it's just better to sort of have anyone can contact the commission. And there's always some unfairness in the sense that somebody's last, but that's true with the sunshine cutoff too, that somebody's last. So that's something for the commission to consider, I think.
So repeal the
prohibition and basically, at least to some extent, just admit that the commissioners are getting information and then facilitate everybody getting information to them, so it's basically equal.
Andy?
Well, first, I concur in part with what David said, not necessarily the result. I think that the sunshine process needs to be fixed and is one of the bigger problems. But to my mind, by far the biggest problem is the inadequacy of disclosure under the current system, which Joe referred to in his opening remarks. Groups like mine are very dependent on having an idea about exactly what kinds of issues are presented. So this could be fixed by clarifying yet again that more than a 1 or 2 sentence summary is necessary for notices of oral ex parte communications, and more identification of the process. A major loophole is the consistent with prior pleadings thing. Well, if your comments say that you'd like no less than 30% of whatever to be the rule that's adopted, you go in and then argue to a commissioner that 60% is the right goal. That's consistent with no less than 30, and that's a big problem. One element of my solution would be something else Joe referred to, making the staff part of the process. Staff is supposed to get a copy of ex parte communication. I think staff should be tasked with flagging notices that are inadequate.
And so that would be the person to whom the presentation is made.
That's correct.
Because sometimes the staff, if the bureau staff are not present in the meetings.
That's right. That's a part of the solution. I think that ex parte notices should be reviewed in addition elsewhere in the commission, and ones that are transparently inadequate should be flagged both by some sort of review process as well as by the parties to the meeting. I think that this will not become excessively burdensome because people will start complying. The problem right now is there are loads and loads and loads of incomplete ex parte notices.
So, Jeff?
So, may I make one very small note? I object on principle to the use of the term ex parte as a noun, as in I filed an ex parte. It offends my 8th grade grammar teacher.
So I'd actually go even a little further than Andy, except for that last part, which I don't really have an opinion on.
We'll add that to the rules.
But Andy mentioned that there are a lot of ex parte filings which are transparently inadequate, but I think the real problem is the filings which are non-transparently inadequate, that omit information that is important, especially important to other parties in the proceeding, but where it's not clear. And the 60% example is a good one. If someone left that out, I would have no way to know as a third party that was said in the meeting and that it was left out. So I think, as you said, commission involvement in this process is key. I would even push that a little farther, if possibly only for the sake of discussion, and say that perhaps like a lot of other agencies, the commission should actually write ex partes. And the ex parte rules as they stand show a recognition that there's an incentive here for parties to omit things, to delay things, that it gives them an advantage to be able to present things to the commission but not actually state that to the public. And so if you really want to create incentives to disclose these things fully to the public, you could do something like have the party file an ex parte and have some commission staff file an ex parte, some description, without seeing the other parties, so that there's an incentive there not to leave things out, because it will become painfully obvious when commission staff says something that you did not list that same thing in your own filing. So that would be one way. There are a lot of other small things you could do. You could include the date of the meeting in the metadata that's listed at the commission when you file a notice of ex parte, which would make it very clear immediately if and how late you were in your filing and if you're a repeat offender. But I think the key thing is that none of these incentives are going to be worthwhile unless there is enforcement, unless there is some penalty or some reason not to violate the rules beyond a private admonition from the commission, please don't do that anymore. This may just be a cultural thing. It may just be that someone at the commission needs to commit to enforcing these rules in a stronger way than it's been done till now, regardless of who that is at the commission. And I just want to flag one other issue for later discussion, is that there is a flip side of this, which is that certain things are allowed to be submitted to the commission on the record, but without public disclosure. Proprietary information, the commission has a setup for that. But there's another side to that coin, which is that some organizations are unwilling to talk to the commission because of the belief, usually correct, that they need to disclose it to the public, and the fear of reprisal from other parties, private reprisal. And so I think there needs to be some discussion of how to address that issue as well.
I think in terms of the sunshine, I think it has to be an all or nothing application. making exceptions in the sunshine period, I think, is problematic. But I think I agree with Jeff and Andy that with sort of one sort of narrowing of the issue. I think within a certain period of time is when I would start applying that the commission staff needs to providing summary. I think that what that would do is it sort of signals as to what issues are actually being discussed and being relevant. So if you take what Andy and Jeff have said, which is the staff would then be saying, hey, we had a meeting, we talked about 30%, somebody files and says it's about 60%, then I think, A, will make the other party, the presenter, more honest. I think it would also signal to other folks sort of these are the issues that are being debated. And so the real hard time is when do you start applying that? I can tell you that in a multi-year process, 80, 90% of the filings are essentially repetitious. It's like, we said this before, we met again with 3 more people, and we said the same thing. But then it gets down into this sort of frenzy of last-minute discussions. And in that point, that's when you need to have a high level of veracity. You need to have a high level of accuracy about the statements. And I think the staff, I don't think it would be unduly burdensome on the staff at that point to sort of reflect, this is what we heard. These are the questions we asked, and these are the answers we got. So I think if we can decide on what time is relevant, I agree with what Jeff and Andy are saying in terms of getting the staff involved to put a check on the outside parties.
Amy?
Well, I think generally the ex parte rules actually work. I think that the honor code is generally utilized very well by most of the community, and I think there could be some tweaking memorandum that could be put out that could clarify a little bit more about what should be in the ex parte presentation or filing, such as, give literal examples as to what needs to be in there. I talked about X filing, or I reiterated X point as stated in X filing, and really get down a little bit more into the nitty-gritty. As to the sunshine period, I tend to agree with the all or nothing approach as well, mostly from a level playing field perspective. If I get called, great for me, but for the person that's on the other end of the argument, and they don't get called, it's a very difficult situation to be in, and I've been in that situation too. So, I think we need to really think about how we make it manageable for the staff, because there is a time that they need to, reflect and actually not have meeting after meeting after meeting, and actually study these issues and get to where they need to be as far as a decision. But we also need to make it fair for everybody. And I would include, actually, for Andy and Jeff, fairness from the standpoint of John Q. Public, who is out there and doesn't necessarily have, a Washington presence, the access that a lot of us sitting around this room do to talk to these people. So I think we need to sort of, this is what this forum is all about, discuss these issues and figure out how to amend and make it better. But generally, I think everybody abides by them well. The other thing that I would mention, and I think we're going to get into this later, but is the new media. How do you deal with it? How do you not only deal with the new media as far as emails, blogs, but calls to the FCC? People. I'm sure the FCC has been getting calls for a very, very long time on issues. How do you record those? Are they different than emails? And again, those will be issues that we need to discuss and figure out how they become part of the record or not. But I wanted to bring that up as another piece of the potential level playing field that we need to discuss.
Jane, what problems do you see and solutions?
At this point, I've got a whole bunch of extra comments to make, but I'll start with the problem that I had thought about trying to identify is one that's a little bit related to some of the things that have been said of timeliness. I think that there are times within the process here where parties have taken advantage of sort of a time gap at the point where the commission is about to make a decision, and sometimes when they're at the very edge of making a decision, there is an ex parte presentation of some sort on which the commission relies that doesn't make its way into the record of the proceeding until after the commission has actually reached its decision. And I think that is a very real problem particularly in the context, I think this happens more in a permit but disclose, but I've seen it in rulemaking as well, that there's something that comes in at the last minute that you don't see the ex parte for a period. I think the solution to that might well be that if you have something that the Commission is going to rely upon, that there is a requirement that it be placed in the record within, an hour. Right? You don't stay with the lengthier period of time, but have something that it must be in the record of the proceeding. I think that's something that could be very helpful. Going back to some of the earlier comments and staying, Austin, within your bounds of civility requirements, I would make a note to Andy's point that it's not just groups like Andy's that rely on the ex partes, but I think it's everybody. This goes across the board. This is not something that is a public interest groups versus industry side, but rather is something that anybody who has an interest in the Commission's proceeding, I think, has an interest in the ex parte rules. With regard to the sunshine period,
and I think his point was that there is a limitation on interested parties, and that should be broadened so that not only interested parties should be able to take advantage of the enforcement piece of it.
Well, and I think if you go to the enforcement piece, I do want to emphasize one point on that as well, which is that I don't think that the enforcement should become a sideshow. I think David Solomon and I have had this discussion a couple of times, that you can get distracted from the real substance of the proceeding if you make too much out of the ex parte. The whole point is that you need to have enough information, and if the Commission is encouraging parties on a regular basis to get a fulsome ex parte in, it may be that a 1 or 2 sentence ex parte is sufficient. That's not it's not immediate evidence that there is a problem. It may be that you've given a full presentation in your written presentation and you've pretty much stayed with it. Now, if you're straying from it, and if the Commission is relying upon that, then I think that it's incumbent to make sure that that is in fact in the record so that people can discuss it. I was going to go to the sunshine period for a second in terms of the exemptions that happen within the sunshine period, which I think is can be a difficult time. A suggestion that I would have in dealing with that, if you're going to retain the sunshine period to give the Commission a period of repose, and having been on the 8th floor, I understand the purpose of having some sort of a period of repose at times, I would say that there has to be a staff-generated ex parte, a notice for any ex parte that occurs during that period. Thus, if someone contacts someone on the outside, then the staff has got to make a point in the record that, in fact, that contact took place, and some summary of what it was that, in fact, happened in there. It would have the effect of, making sure that the record was complete, but potentially if there's some abuses that might come along, it might also be a disincentive to having, those outside contacts if they're really not appropriate in the context of sunshine.
May I add one very small thing? It is a big problem at the end of a proceeding that it is possible to file paper ex parte notices which don't get scanned and put into the record until it's too late to decide things. And that's an easy fix. Anybody who has the wherewithal to be able to make an ex parte presentation at that late stage of the game has the wherewithal to file electronically.
Well,
Okay, let's keep, we've got, and we're going to have a whole time on sunshine, so let's keep going.
I actually agree with Andy's last point, but and that's a good segue to the issue that the Grace issue I have, which picks up on a lot of comments that people have been making. That is sort of the reliance on sort of last-minute flurry of ex partes as part of the process. I think it's very important that ex partes take place throughout the process, because we all work in industries where technology changes and things are different than at the beginning of the proceeding, and I think that's an important point for folks to be able to bring to everyone's attention. But I do think that there can be a sort of a back and forth immediately before sunshine, or at the end of a proceeding if it's not subject to sunshine, that can be challenging for smaller companies that don't have the legions of lawyers that larger companies do to follow, and expensive even for larger companies. And to me, the greatest problem of all is that the FCC staff may not have time to analyze what's actually been said. So I would actually have a different solution than some of the other folks. I think that we ought to sort of clamp down on sunshine. I think a period of repose when FCC staff can actually read what was submitted and think about the issues before a decision is made in sunshine context is very important. So I would have a stricter deadline and at the beginning of sunshine instead of actually at the time of a vote. If you're going to go that approach and give people a real period of repose or of reflection, perhaps is a better way of putting it, just think about the issues and think about what's been said. I also think that the FCC staff, I would also put a role on the FCC staff, a responsibility in the FCC staff, to, as a practical matter, on the disclosure piece, I would not have them. I think it's unrealistic, frankly, to have them actually file anything in the record. But I think it's entirely appropriate for them to go back to the parties and say, your ex parte was not adequate, did not disclose what needed to be disclosed, or if it's filed after a particular time period, just tell people it's not going to be considered. If it's a written submission, for example, during sunshine.
Chris?
A couple quick things before I get going with what I think is the problem or a problem we should address. First, as Austin indicated, I'm one of the co-chairs of the FCBA's Access to Government Committee, and along with my fellow co-chairs Pete Correa, Michelle Cohen, and Howard Weiss, we've consulted with other practitioners and thought about these issues a great deal. That being said, due to the FCBA's diverse membership, I'm not authorized to give the official views of the FCBA, and my comments here today are a reflection of the observations that the Access to Government Committee's seen over its time of deliberation. Second, having given my disclaimer, let me appear to immediately contradict it by saying that the FCBA shares the FCC's commitment to openness and transparency. And like we did in 1995, in the last time the FCC revised its ex parte rules, we stand ready to facilitate the Commission's review of the ex parte rules by offering to organize a seminar or an event for our members to express their views on the ex parte rules and to share their experiences with the operation of the rules. Additionally, the Access to Government Committee, through a discrete email address, plans to canvass the views of the FCBA membership and pass those along to the Commission in an appropriate manner. And finally, if the Commission initiates a formal docket and some sort of comment cycle, the FCBA plans to notify its members and encourage them to provide formal and informal comments to the Commission. Now, shifting over to what I think what problem I would point out, I think I'd like to cheat a little bit with my answer because the FCC made great strides in addressing it last week, and it's different from what's been brought up so far. As Joel noted, the current ex parte rules were adopted in 1997 before the FCC shifted from paper filings to a heavy and, in many places, a mandatory reliance on electronic filings. As part of this paradigm shift, the FCC implemented ECFS in 1998 after the ex parte rules were adopted. The initial version of ECF was a fine filing system of comments and reply comments, but it wasn't really more than that. Then, last Friday, an FCC team led by Bill Klein unveiled ECFS 2.0. And I think it's fair to say it revolutionizes the filing and retrieval of comments and how users can manipulate those comments in the database for their purposes. Some of the features include the ability to file multiple documents and multiple rulemakings, advanced search and queries of both filings and rulemakings, the ability to extract comments, really simple syndication feeds, and the ability to export data results to Excel or PDF formats. It's really nothing less than amazing, and I encourage everybody to take a look and learn how to use ECFS 2.0. It is a huge upgrade, and I can't commend it enough. And it shows that technology can perhaps be a solution to many of our many of the issues with the ex parte process. My unabashed praise for the system upgrade also suggests how we should go about reforming ex parte rules. We should take into account ECFS and the electronic methods. Two examples come to my mind off the top of my head. And like Andy suggested, and a couple of folks have already agreed with him, but perhaps even more so, there should be mandatory electronic filing of oral ex partes. And second, in terms of service, any electronic filing should be presumed served once it's posted on the system. That would be great efficiency to many folks and would cause more people to rely on ECFS. The greater reliance we can give to ECFS will improve the process, will improve speed of access, and I think it should be used to its fullest.
Thank you.
Discuss some heartburn on issues, some issues people have raised.
What we're going to do now is move to an agenda of the substantive issues that I think touch just about everything that we've got here, but then at the end we'll try to move quickly enough to give you a chance for, if you still have heartburn, you can let us share it. Chris, thank you for the plug of ECFS 2.0. I think it is terrific, and those who haven't visited our website to take a look at it. I think we even posted a tutorial is posted, I think. There's a link to the tutorial. Yeah.
I think the tutorial is posted, and I think I've suggested, I haven't been able to find any faults with it, but my understanding is if you find issues with ECFS 2.0, it can be easily upgradable, and those any issues or any suggestions should be forwarded to the folks who run ECFS, Bill Klein in particular.
2.1 is on the way, I guess. I wasn't sure that we would have an audience today, and we do, and appreciate that. But as an aside, if anyone in the audience has questions, just in your best penmanship, you can feel free to write them down. And Pete, would you mind raising your hand? Just hand them to Pete, who will get them to us, and at the end we'll try to make time to ask some of them if they haven't already been addressed. I'm now going to turn it over to Joel to start touching on some of the problems that the panel has identified.
Right. One of the issues that we've discussed most so far goes to the level of detail in the ex parte summaries. And one question that we've been thinking about is whether those types of concerns can best be addressed by modifying the rules, or whether they can best be addressed by a stronger enforcement mechanism. And certainly in the context of enforcement, one question that comes up is, since a summary by definition is not going to have every single detail, except in extreme egregious cases, is an enforcement mechanism the best way to get at the problem? And I guess I'd ask David first, given that you've spent a lot of time dealing with enforcement issues here at the Commission in the past.
I guess I'm sort of worried about starting a cottage industry, although maybe I'd benefit from it, but starting from a cottage industry of kind of enforcement practice on the ex parte rules. And I guess what I think would work better is, and maybe it needs to be modified some, I'm not sure, but sort of what traditionally was kind of an informal process that pretty much worked, I think, which is to the extent that someone was concerned that a summary was sort of grossly inadequate. And I know we used to get these in the General Counsel's office, and it wasn't necessarily parties, press could do it, anyone could do it, would simply write a letter and say, so-and-so filed these comments, I think, and they might categorize it as a complaint or letter, but I'm complaining that so-and-so's comments violated the ex parte rules because the summary wasn't enough. And typically the General Counsel's office would send that complaint or letter to the person who filed the ex parte summary and say, we've received this complaint, please comment. And typically what happened from the party who received it is they said, we think our summary was sufficient, nevertheless, here's a more detailed summary, and that was kind of the end of it. And it seems to me that sort of works, and to the extent that there's some egregious thing where you discover that one entity, 50 people are filing complaints every year saying every single summary they file is inadequate and they simply fix it after the fact, maybe they need to be spoken to or dealt with. But it seems to me that I would want to avoid, and I know this happens more in restricted proceedings where the ex parte rules are more significant, but you get this sort of sidebar where everybody's sort of screaming at each other in pleadings about outrageous violations of the rules and what it means for their character qualifications and all of that. And sometimes that's warranted in the restricted side of things, but in the permit but disclose, it just seems to me that the focus should be on if there aren't adequate summaries, helping get adequate summaries in, and not having sort of a side practice of complaints about people.
I think the issue here is the statement made relevant? If it's it's an irrelevant statement and nobody relies on it, who cares, right, at the end of the day? So the issue here is who's identifying. So if the commission takes a statement from Jeff has an inadequate disclosure of it, the commission then relies on it, puts out an order. A party like myself would say, wait a second, you can't rely on the statements that he made in which I had no chance to respond. So I think the issue here is somebody's got to make the determination based on the reliance of the information. So I think the enforcement mechanism, it sort of already works, but the problem is who's the person identifying in restricted proceedings, because you have narrowed who can participate. What you have is sort of this self-policing mechanism, and permit and disclose it. So anybody could come in, and then somebody in the commission relies on it to take a position, and it's sort of after the fact, and it becomes too late. I think that's the challenge that I see.
Go ahead. Does anyone want to take a position in favor of stronger enforcement?
I would be happy to take that position. I don't think enforcement needs to be incredibly strong, and I also don't want to create this cottage industry of an ex parte violation enforcement proceedings. But as you said, the commission can just say stop. But I remember a Robin Williams bit about how in Britain the police don't have a gun and you don't have a gun, so that all they can say is stop, or I'll say stop again. When you're in that sort of situation without the actual stick behind it, there's no reason to actually stop. There are plenty, I don't know about plenty, there are organizations who do consistently file late filings, incomplete filings, and occasionally there are letters sent, and occasionally they're admonished not to do it, and they do submit a replacement filing. But as long as there's no real incentive to stop doing this in the long run, I think it will continue. So I think there does need to be some sort of stronger enforcement, and I don't know what the sanction is, whether it's a bar on oral ex parte presentations temporarily or some other sanction, and hopefully it won't be used very often, if ever, but the presence of a credible threat is necessary to actually changing people's behavior. And to that end, I think the commission will always have either explicit or implicit discretion in how it applies these things. So, if someone files a ex parte 1 day late and someone else comes in and says, you need to bar them from presentations for a year, the commission will say that's ridiculous. We don't need to do that. But at the same time, if someone is repeatedly and egregiously violating the rules, there needs to be some sort of actual punishment available.
I think that the real point, though, in terms of that, is that the commission has not just got the ability to just say stop. I mean, the commission has the ultimate power here that it's not going to rely on whatever was presented in the ex parte communication. And in fact, it's in the commission's interest to do that, because if the commission in fact does rely, and this is to John's point, if the commission does rely on something that is not a part of the record of the proceeding, the ultimate sanction is in the courts through administrative procedure, and the commission has had those through the years. I mean, the various cases that have been returned over time because the commission is in fact relying upon something that's not in the record. That's the commission's interest, is in making sure that happens. Now, having said that, I agree that there still should be encouragement to have fulsome ex parte notices in the record, because I do think that it helps to inform the debate, whether or not it's specific reliance. There should be a fulsome discussion so that can take place, so that the commission can make better decisions.
I would just to pick up. I'm sorry, Jeff. Do you want?
I'll address one part of that real quickly, and I agree with what you said, except both Jane and John. To the extent that we're worried about reliance on these things that weren't fully disclosed, part of the problem is it's easy and common to rely on something without relying on it explicitly. If it changes your mind, but the record is complete enough that you have other justifications for the decision, then that, it's a problem that will never fully be solved, but it's a problem that we should try to solve as best we can.
I think one way to do this is to make it, first of all, I would have ex parte filed for every meeting so that you don't run into the problem of meetings happening without, in inappropriate proceedings, where you don't have the problem with meetings happening without having any kind of ex parte filing be a record of it. But I also think it's very, one sort of simple and effective enforcement mechanism is to have one staff member who attends the meeting to simply be responsible for eyeballing the filing and making a determination whether they think it's adequate, and particularly if they think that there's something in there that something that was discussed that's not in there that might be relevant to the decision-making process, and then they call up the party and say, look, I'm sorry, this wasn't adequate, and they're responsible for redoing it instead of putting the onus on the FCC staff. I think that you have a couple of months of this, and people will clean up their act, and I think that's. I think that's an effective enforcement mechanism. And the ultimate one, as Jane said, is that if it's not in the record, it can't be relied upon. So I think that's a practical way of moving forward on it, and I think it would change the practice, which doesn't affect the underlying legal framework, but it would change the practice relatively quickly.
Diane, having worked for 3 commissioners, do you think that the commissioners would want a staff person sitting in on every meeting that he or she holds?
Then I think, I think that they typically do. They don't necessarily always, but I think at that point it's the commissioner's obligation to take a look themselves. I just think that that's a more practical solution than requiring the commissioner to file something, which is clearly not going to happen. And I think that that's the best. If the commissioner found a particular fact that's of interest to them and made an impact on their thinking, then yes, I would think they would want it revealed in the record what was articulated during the meeting.
I just quickly want to present the sort of a factual situation so we understand the context. I think what we're all circling around. When you have sort of the last-minute flurry of decision-making, and I also want to point out that we're talking not just about agenda items, but also circulate items in which this dialogue goes on. You have a dialogue in which, let's say, a commissioner asks the other party, the outside party, what if this hypothetical happened? And a party responds and says, well, we would be okay with it, or we would not be okay with it, or there's this issue, whatever. Some statement is made that is material in terms of what people think about. And so the question that we really need to focus on is if that response is not identified in the ex parte. I'm consistent with my previous position. I haven't changed it. But in my dialogue, I answer this hypothetical this way. That's actually very relevant. And that's the kind of candor I think you want in these ex parte filings. And I think that's the challenge that we're all facing.
Diane made a couple of points that actually were going to be a couple of our next questions, and I'd actually on one of them like to quickly go around and get a thumbs up, thumbs down on whether people think it would be a good idea. Under our current system, people don't even need to file a summary if they've simply reiterated what they've already said in prior written filings. One approach would be to require a filing for every ex parte meeting, but if it was something where you simply reiterated what you've said before, you would need to cite specifically to what pleadings you address those points in. Going around starting, you can start, John. Do you think that's a good idea?
I think that's a good practice. But I'm not sure it's material, but I think it's a good practice for everybody.
Jeff?
I think that should be part of the rule for every ex parte, that you need to cite specifically where you've made arguments that you are just, as Andy pointed out, the consistent with prior arguments. You need to say where you said them, so that would include meetings that only consisted of those.
Andy?
Well, I do have a concern that this has to be carefully drafted so that it does not become a means of evasion by simply referring to pleadings and not elaborating where there was elaboration on, again, the consistent with problem. But with that proviso, I would support it.
David?
I want to add a sort of unintended consequences point that, well, in theory, I understand the value of that. Sort of it would have to be carefully crafted because, and if think back to sort of the way the rules work now, they say you have to disclose presentations, and then it says, but if you just summarized your comments. So technically, now maybe you could define meeting in a way that's different than presentation, but people interact with the commissioners all the time. And so I think one of the things you'd have to account for is, okay, right now when Andy's on a panel with a bureau chief and Andy says, I really think we need to, cut back on broadcast cross-ownership. Andy doesn't file an ex-parte presentation because everybody knows that's Media Access Project's position. But technically, that's a presentation, and you want that to have to be filed, or you're at sort of all sorts of contexts of, commissioners grab people at cocktail parties and the like and have brief discussions, and typically you're just saying what you've said for, a million times and everyone knows your comment. Every time you talk to a commissioner, are you going to be filing an ex-parte summary, and therefore you to get into more enforcement sort of actions. I saw Commissioner so-and-so talking briefly with this person, and I didn't see any ex-parte presentation in any docket, and I heard them, say the following word that's one proceeding. So I think you'd have to think about it. Maybe if it's a visit in the office or it's a meeting or somehow defined, so that you're not. There's also kind of a fleeting exception, I think, in the rules too, but that you're not getting in a situation where sort of you make the rules unmanageable. I think part of what the Commission tried to do in adopting them, and OGC when it was working on them, was have rules that would work most of the time, but at the same time wouldn't sort of paralyze people to figuring out that, every time they opened their mouths they had to do something.
Chris, consistent with your caveat, do you have any?
Well, I think, first of all, it's kind of standard practice among the bar to make a filing every time you go in for a meeting. So I think the need for it is not as great as we might think it is. That's why you have so many of these ex parte filings now. I went in for a meeting with X. We discussed our pleadings, and this is consistent with what we've already filed. You wouldn't have those if people weren't already following that practice.
So why do you think parties file those notices?
I think that parties want to comply with the letter, the intention, and don't want to violate the rules, so they do belt and suspenders. They go ahead and file, and even though they're not saying anything in the filing or not required to by the rules, they disclose it voluntarily.
It's a perception problem.
Yeah.
Right? You don't want to be accused of having a back room kind of meeting, so the best way to ensure as a member of the bar is to say, we filed and we discussed this thing. There's sort of the cocktail party is a widely attended exception, right? But I think the key here is people want to avoid and don't want to put their clients in a bad situation by saying you did a back room kind of thing. I think the problem is is it relevant? Is it material for the decision maker? If we can't parse that, then all the filings and I'm not sure they matter. It's good practice.
Yeah, and I think any rule change, you need to be really careful with the wording so that you didn't swallow up exceptions like a call to the Commission to say, where is this, the status exemption update? That's just a pure status update. And so I think we need to be careful, but I don't think it would change standard practice much at all.
Any additions?
Yeah, I agree with Chris. I mean, I think most people do file anyway when they go in, whether they say something different from their pleadings or not. But I also associate myself with David's comments that I think we need to be practical about this and not try and define things to a point where they're just not realistic or not practical.
Jane?
I agree. It's a good practice to have something in, and I think it's fundamental fairness to have people know that someone has come into the Commission, but I also agree with David's practical points.
Amy?
I would agree with what the last two said as well, and I think there are some exemptions as far as the presentations, presentations such as these that are spelled out in the rules already, or certainly spelled out in the FCC guidelines that are on the website. So practical, but a decent set of disclosure, a decent filing that says what it needs to say, so that John Q. Public, as I said before, not to mention everybody else involved with the proceeding, knows what was said generally.
Before we move on to the next topic, I have one last question on this one, which again I'd like to get a quick thumbs up, thumbs down from people, whether they think that staff should be giving a thumbs up, thumbs down on each ex parte that's filed, so that someone, at least one person who was at the meeting from staff, either looks at it, says this is an adequate filing, or at least gives, if they don't think it's an adequate filing, gives the party a call and says you need to refile something. Good idea, bad idea? Why don't we start with you this time, Amy?
You know, I mean, I'm concerned about burdening the FCC, I mean, especially during sunshine times where, you know, things are moving fast and furious. You know, I'm not sure that you're going to actually have enough time to do some of these things, but, or even have the staff have enough time to do it. I think generally, when I go to meetings, we talk about the ex parte before we file it. You know, this is new information. Is it in the record? Yeah. Okay. If not, I'm going to put it in the record, and that's part of my ex parte proceeding. So maybe just some discussion during the meeting or at the end of the meeting about what's going to go into the ex parte is more appropriate than sort of after the fact.
Again, I think it's a good practice, and I think it's a best practice for someone at the meeting to take a look at that. And in the time that I was in the commissioner's offices, I used to do that. If I saw a filing that came in that was inadequate, I was known to call people and say you should do something better. I think that should be a general practice. I'm not sure it should be the rules that can be cause unintended consequences, as Amy just talked about. You don't want to discourage a meeting that needs to take place by having something that can just be a constraint.
When you made those kinds of calls, how much pushback did you usually get from people?
Not ever. I mean, seriously, I mean, whenever those who are out there and know, when you make the phone call and say, look, this really, you know, this isn't enough. This doesn't really reflect what went on, and if you want the commission to be able to rely on it, you're going to have more. And you don't get any pushback on that.
I agree. I mean, the only person that can really do this is an FCC staffer who's at the meeting, because they're the only ones that know if there was an important point that was discussed that's not in the ex parte. They're the only people that know that.
Chris?
I agree. It is a best practice. And also, to the extent that it needs to be in the record, there may be a divergence between what the staff member thinks should be in the record and what the filer and what the staff member is looking for in the ex parte. The staff member can push back and ask that be included. It may be that there was a question that was unanswered that didn't get answered in the ex parte, and that's what the staff member is looking for, and it's appropriate for the staff member to push back on that.
David?
I think it makes fine as a best practice. I'd be careful about making it a rule, just because I think you're setting people up to fail, and particularly the commissioners and their staffs. And I just think, I mean, they have so many meetings, and particularly with ECFS, so every legal advisor has to go in ECFS and put in their own name for the last week and do it once a week, and then print out every ex parte summary to see what's there. Because in ECFS, you only copy. In the old days, when you did the hard copies under ECFS, you just put it in ECFS. So I think it's a good practice for the staff to do it, but I'd be careful about a rule that, again, could lead to people sort of violating it when they're trying to act in good faith.
Andy?
Well, I think it should be mandatory. I think that common practice, certainly ours, is to send a copy of an ex parte notice by email to the staff who attended, as well as file with ECFS, and that's easy enough to do. And I think that very quickly, knowing that somebody's actually going to eyeball these things will lead to much greater compliance. I mean, the reason we don't like those speed cameras is because they work. And this will work.
Yeah, I would agree with what Andy just said. In other agencies, the staff have a much higher burden on what they have to what kind of effort they have to put in to talk about ex partes. I think that this is the sort of thing where the burden of reading over an ex parte and signing off on it is much, much lower than the actual writing of it. So I'm not too worried about the unintended consequences.
I think I would agree with my public interest brethren here, but I would add language to the fact that you make it a rule, I would add relevancy and materiality. I mean, it's sort of, if it's material and it was relevant, you have an obligation as a staff member to do that. When I was in the Wireless Bureau, and before that, when I was chief of the enforcement division, because before David upgraded it, we had to look in the record. We had to make sure everything that we relied on the record was documented, and that's when you'd make a call and you say, hey, you told me this, but you didn't have it, and so on and so forth. So I would put in material and relevant.
John, I'm thinking of a permit to disclose rulemaking proceeding. Mm-hmm. Let's say one that continues over a number of months.
Years.
Or years. The end game, the sunshine period, the month before the sunshine period, relevance may be relatively easy to determine, particularly if you're talking about the Bureau staff who are directly involved in the drafting, or a commissioner who is considering how to vote. But at the earlier stages, at the issue framing stages, how do you decide relevance, and do you envision a system where, which is something like what we have now for some intergovernmental communications, where you would go back and put the information in the record if you later determine it to be relevant and you didn't see the relevance at the beginning? How do you handle that time problem?
I mean, I think there's a whole host of things that need to be done, which is, I think it all starts out with that timeline issue that I mentioned. But I think to the extent that your views evolve, or the staff's views evolve, or that commissioners come in and sort of ask questions that hadn't been sort of properly framed, I think that's absolutely the exact dialogue that the commission staff ought to be having with outside parties. Now, once you start having a dialogue with, let's say, one party, the ex parte rules kick in, right? You've got to let other people know so that they can inform and add to that information. So, I think it would be great to have, within the sort of governmental deliberation, put in an exception for, like, here's what we think the record reflects, right? Some interim summary of what the record reflects, and I think that gives you a perspective on where people are heading, and people can come in and say, no, I think you found some information to be wrong. So I think it's absolutely the right approach. That's exactly the right dialogue we need to have.
I was going to say, I think, for those of you who are lawyers, that the relevance standard in court is very broad. Anything that, might make something more or less likely. And I think that's sort of the case here. And I don't think there's really actually a lot of debate about whether something is relevant. In general, it's relevant to a proceeding, not if the commission ends up relying on it, but if it's, it's on the related topic and might in some way sway them one direction or another. And so I think keeping a broad standard is good, and I'm not really worried that someone's going to come in and try and argue that, when you talked about the Jets game, that was actually relevant.
So that's the current standard. That's essentially the definition of a presentation, whether it goes to the merits.
Exactly.
Okay.
Yeah, so I think that's good.
And John, is that your standard as well?
Well, I just want to make sure that I was trying to address the question of when does a staff member have to go in and sort of supplement the record, is when they find it relevant and material, not whether the outside party thinks it's relevant or material.
I would agree.
If I could add one thing that David and Andy made me think of. David mentioned that staff members now have to go in and search ECFS almost on a weekly basis to see what's filed, and Andy mentioned that his standard practice is to email it to the commission staff in the meeting. I think Andy's practice is the generally accepted practice of emailing it to the staff members, but I quick checked the rules, and with electronic filing, you don't have to email it to the staff member. I think perhaps a rule change would be to maintain the old method of serving or copying the commission staff members involved in the meeting, but allow that to be done electronically through electronic mail, which all the commission staff members' emails are available online.
I think we should probably move on to the next topic, which we'll address, I think, much more briefly than the one that we've just talked about, and that is the series of exemptions that exist under the ex parte rules. And rather than going through them exemption by exemption, I think I'm just going to ask whether there are any exemptions under the current rules that you think should either be broadened or narrowed. And for now, let's not talk about the sunshine period because we're going to have a separate section on that. But more generally, and why don't we start with you, Jane?
Just in terms of that, I mean, I think that the exemptions serve a purpose. The one that I do have some concern about is exemptions that go with, congressional contacts. There really should be a record of the fact of the contact, if not, some summary of what's in there. And if it were to be broadened, I think that could well be broadened to state governments, which I think is an appropriate place. I mean, there can be contacts there as well, but there needs to be some record of that. I think in the proceeding.
Can I just jump in?
Absolutely.
And maybe I'm mistaken, but my understanding is if Congress or a staffer up on the Hill actually contacts somebody at the FCC and the staffer at the FCC or commissioner finds it material to that particular proceeding, they have to file an ex parte. So the question then gets to, the subjective nature of that particular contact. Maybe the exemption is done away with, and all of those, just as we were talking about all ex parte communications being on file, even if you're just reiterating the record, adding that particular requirement that all contacts be, stated in the record.
I think that the part of the difference is in who does it. I mean, you're right that that's the way it works, and I think the reason that there's some of the exemption that's in the rules is because there was an expectation that perhaps congressional folks would not file something in the proceeding, and I think it was largely a practical matter that the commission said, well, under those circumstances, that it ought to be the staff person who puts some sort of a notation in there that there was in fact the contact.
Right, that's my understanding.
I think this all goes like the Pillsbury case, in which there are limits to what folks in Congress can actually do in terms of weighing in into the process. So I think the idea is to record all of this. I mean, let's be practical. A lot of the problem is it's not with the substance of what's being said. It is the sort of political pressure point. And I mean, I'm not sure that any amount of filing will actually ever discover, the atmospherics that surround those types of contacts.
No, but I think from a response standpoint, if I knew that ex-senator, contacted the commission and I had a contrary view in that particular proceeding, I might go to that senator and say, hey, what are you thinking? Why do you say this? And give my particular, side of the story. They may contact the FCC back and say, you know what, I heard the other side, forget what I said. I mean, there's just some, I think the transparency nature of those contacts, and we can get into the sunshine period later, but, I think we just need to be consistent with Congress, public, everybody.
Does anybody think there should be a different rule if the contact is coming from another agency in the executive branch? There's currently an exemption for situations where the commission shares jurisdiction with another agency, but what if the other agency simply has a common interest but doesn't share jurisdiction?
Well, I have a problem which I think extends beyond the scope of today's workshop, but I do want to identify it because it's a huge problem. It is common practice in large transactions where, for example, there's a Hart-Scott-Rodino filing or some similar filing reposing in another agency, for commission staff to visit the other agency, review documents, have nothing mentioned in the record that this meeting took place, that they reviewed on these documents, and relied then upon these documents. I think that it's necessary for communications with other agencies where there is material that is used to be identified and be made part of the record. And whether that's by altering the ex parte rules or in some other way, it's a big problem.
Are you concerned that your suggestion for disclosure of those documents, and I think you're referring to the Department of Justice. Those documents have typically been provided to the Department of Justice on terms that wouldn't allow their inclusion in our record. So are you content with the idea that those conversations wouldn't occur at all, that the information gathering wouldn't occur at all if disclosure were required because of the Department of Justice's restrictions on use of its documents?
Well, it's not part of the record. So in theory, it's not relied on, but in fact, if it's reviewed, it is being relied on. And so I think some sort of disclosure or identification of documents that have been reviewed, even if they're provided on a basis that they can't be released, at least gives people notice that this has taken place. I mean, just finding out that these meetings take place and that is very hard and has required FOIAs and all sorts of correspondence just to find out that people went over to another agency and visited documents there.
I think, I mean, in addition to what Andy said, I think the notion of the FCC being an independent agency and then having the executive branch sort of have undisclosed contacts, I think, is problematic. And my understanding is that's not supposed to happen. But to the extent that it happens, I don't think it's unless there's a really highly identified sort of public safety or some national defense type of situation. I'm not sure that we should make any exceptions.
Does anybody disagree with Andy or John?
I have some concern about making sure that there continues to be the ability of the Commission to collaborate with other government agencies. I think there are times when you have shared jurisdiction. I think I do make a distinction between the context of shared jurisdiction versus someone who just sort of has an interest and wants to come in and maybe attempt to influence the proceeding. In a situation where there's shared jurisdiction, you need to have some ability to have some conversations that aren't necessarily a part of the record. This, in some ways, is akin to the litigation exception. You have to have some ability to understand where the Justice Department or the Federal Trade Commission may be thinking about an issue in order to fully understand the full context of how the Commission there. And you're not going to get that information if it's required to be revealed. Now, I don't disagree with all of what Andy said in the sense that I think that if the Commission, and this is, I understand the way that it works, is if the Commission has gone over to look at documents that may not be, that they can't, that they cannot say we rely on these because they're the Justice Department, they've been held back for some reason or another. If the Commission thinks that it should rely on those, the context is that they should then ask for those documents. And it's perfectly appropriate for them to do that. And if it is that they're going to rely on them, that's the way that should be handled. I'm not sure how much you get out of knowing that people at the Commission talk to people at the Justice Department. We all know that people at the Commission talk to people at the Justice Department.
I think the biggest concern is actually relating to the ex parte, and I mean, I 100% agree on the shared jurisdiction, but on when there is not, there's an interest as opposed to a shared jurisdiction, the problem is it goes to the ex parte, the disclosure, the fairness of it all. If somebody goes in to another agency, sort of lobbies them to take a position, and then those folks come in and weigh in, and there's not this record and communication is not clear, you've just found an end run around what the Commission is trying to do by being transparent. So I think that's a big concern.
Any last thoughts before we move on to Sunshine?
I don't know if this would be an appropriate place to talk about the sort of retaliation problem, because there is an exception for that in the ex parte rules, an exception for when the Commission, I forget the exact wording, but when the Commission has promised confidentiality because of fear of reprisal. But I can tell you from a practical standpoint that is very rarely used, and most parties who are in this situation don't know about it and wouldn't know how to go about using it. So perhaps that exception should be expanded, or it should be made more explicit what the procedure is for getting confidentiality, because in a lot of these cases these people are unwilling to even publicly admit that they've talked to the Commission, because that is enough, And even if this were fully confidential, there will be some difficulty in going to the Commission, because people eventually find out who you talk to. But I think that needs to be expanded in some way, and perhaps there needs to be the stick again that says that if there is reprisal, the commission will do something about it. But to encourage those people, because I think important things, certainly in several proceedings I've worked on, important things have been left out of the record because there is no way to convince the suffering parties to go in and talk to the commission.
Right. But I guess the question that comes up when you were to use that exemption is how then can the commission rely on something that isn't part of the public record and that no one else can reply to?
That is absolutely a difficulty. The commission does do it in terms of getting proprietary data from many organizations and corporations. It's a difficult problem because that also presents the same problem. It's the same problem on both sides of the issue. But
right there, we typically, though, would, let's say, allow outside counsel to see the information under a protective order. Could you envision something similar here?
Yeah, absolutely. I think there need to be similar checks in place because otherwise there's always the potential for abuse. So checks like that would definitely be a good thing to have. I think the problem is solvable, although so perhaps just expanding the rule alone is not enough. But expanding that whole area of exception with appropriate checks in place, I think, would be a very positive thing.
In our earlier discussion, there seemed to be healthy interest in the sunshine prohibition. Just for a common understanding, 1 week before the monthly commission meetings, the commission will publish an agenda of the items to be considered at that meeting. From the time of publication of the sunshine notice through the release of the item, with a couple of exceptions pertaining to the period after adoption and before release. Ex parte contacts are prohibited unless they are solicited by the commission and the information that is produced from that contact is put on the record. David has identified this is the biggest problem. A number of you focused on it in your 1 minute on important issues. But Amy, you said something that resonated with me, that the rule has to balance an interest in giving the commission time to reflect, which I think is both a practical decision-making imperative, but also relates to the Administrative Procedure Act requirement of having a record to which we respond. In the State Farm case, that we have to respond adequately to the issues raised in the record, and if the record is moving, that's very difficult to do. But you also said that the process needs to be fair, and I wonder if you'd mind starting us off.
Well, there's a lot of fairness issues in it, and always, as David mentioned earlier, there's always somebody that's going to be last and somebody's not going to be able to respond to that. There's always going to be that situation. But I think that there are instances, we talking about the exceptions again, Congress can, talk to the FCC, can call the commissioners, no problem. Well, my strategy then would be, okay, I'm going to go to Congress. I'm going to get Congress to go to the FCC and figure out how to make this work in order to get my position, listened to. I think that's a little bit of a roundabout and non-transparent way of going about things. So, and again, getting to some of the public interest sides over here, I think for the general public, they can't do that. They don't have the access. They're not here. So I think that we need to think very heavily about whether we keep a time, and maybe it's not a week, maybe it's a couple days. Maybe we change the time frame of how long, this is, and give people a little bit more time to respond. I'm a little concerned about having no contact at all. Because such critical decisions are made and people focus. As John was saying earlier, there are so many issues that are happening at the FCC, and people really focus in the last week on that particular issue that's on the agenda, heavily at that time. So that's when questions come up. People want to reach out. So I would just as soon get rid of the sunshine period altogether and have at least an additional dialogue. And frankly, if commissioners don't want to meet, they don't have to meet. They don't have to call. They don't have to accept your meeting. So, that's how I would do it personally.
Maybe we should go around and Jane, why don't we let's start with the question of eliminate entirely or not, and take off from there.
I have some hesitation about eliminating entirely the sunshine period. I think it does have a purpose to give the commissioners time to reflect. But I think it's important to recognize that the sunshine period and the ex parte rules kind of have different purposes. The sunshine period has the purpose of repose. The ex parte rules are intended to provide transparency in the process. I think you can meld the two. If what you have is that there really does need to be a record of any contacts that are made during that period, whether it's the commissioner calling out or Congress calling in, just a simple record of that. It would be that would keep the transparency, but you would also have that opportunity for the commissioner to say, okay, this is the time period. What it really does is it gives them the time period to say, I don't want to take a meeting, without it becoming a cause celeb, which it does if you don't.
I actually really think it's, as I said earlier, I think it's important to keep the sunshine period. I think it's really essential to sort of a thoughtful and frankly fair decision-making process for the commission staff, including the commissioners, to have time to actually think about the arguments that have been made. And I think that this is a practice that's sort of evolved over the last decade or so of more abuse than following the rules. And I think it's a simple matter of fixing it. I think you probably, as a practical matter, need an exception for members of Congress. That's just real world. But I think it's a good idea to keep the sunshine period and to make it much more real than it is today. And I think that's sort of taking things back to the way people used to take a lot more seriously than they do today. And I think that would be a good idea.
So, are you suggesting no rules change, but
correct
a stricter adherence?
It's stricter, exactly. I mean, I think the rules are what they are, and it may be that on very rare occasion, the staff really does need to ask, have some kind of, ask for information. But basically, what we're talking about here is moving a deadline. The deadline's either at the day of the vote or the deadline's a week before at sunshine. It's a deadline. And I think, this probably should be coupled with some kind of advance notice that something's going to be on sunshine so people don't get, sort of chopped off. But I think that, there's going to be a deadline. You might as well have it a week ahead of time so people can actually think about what's in the record and think about the arguments that have been made. That's my view.
If one of the problems is that the decision makers don't really want repose, why should the rules attempt to force them there?
Obviously the commission can do whatever they want in terms of, it's a commission decision. But I think it really is something that promotes fairness to the parties involved and promotes a more thoughtful decision-making process. And I think it's something that you need to get consensus on. But, it's a commission-level decision, of course.
I think one issue in terms of the sunshine period and discussion that's been addressed, you've got open letters that might be put in newspapers, ads taken out in Com Daily, and now you've got the FCC's blog and efforts to go into new media. I think what's on the record needs to be defined, and that you can still participate in the public debate outside of the record. And it could well be that the FCC's blog is not considered part of the record, even though probably you should have some ways to add whatever you're posting into the record. And so, yeah, you would still have this kind of outside public debate, but the official record would be closed off at a certain time. And I think there are ways that you could combine the blog into ECFS, and that might be an ECFS 2.1 fix, where if you want a blog posting to become part of the record, you've got some sort of connection that you hit a button and then you fill out greater detail in terms of form, and you can add it to the record if it's still within the sunshine period. But otherwise you might be outside.
Is there a material difference, and let's start with the perspective of commissioners and commission staff, between an electronic submission and a phone call or a personal visit? Should we be attempting to distinguish from those? And I guess when I frame the question more broadly, is there a practical difference in terms of repose and the objectives of the rule? And also, is there a difference to the interested community, the most obvious being that something filed on ECFS or on the blog is immediately available to all those who have access to the Internet, and that frames a third issue, which is that fair to those who don't have access to electronic filings, at least don't have ready access, don't have a computer at their office or work?
Well, I think you could shut ECFS submissions down with the sunshine period, and so that anything that's received after the sunshine period you could keep from being posted or part of that record. In terms of emailing a commissioner, if you do that, then that is a direct contact by any definition. But a blog posting, whether it be the FCC's blog or your own personal blog, a letter to the editor or an editorial in a newspaper like the Wall Street Journal or the Washington Post, I think those do go outside the bounds of direct communications and go outside the record. They're part of a public debate that's not the FCC record. I think there needs to be a line drawn between those two.
I think one of the questions that Austin was asking is whether maybe we should have a more relaxed standard for electronic filings, both because they impose less of a burden, arguably, on commission staff than taking a half hour or 45 minutes out of your day for a meeting, and also because other parties could see them immediately and, if they wanted to reply, could reply.
So keeping the electronic record open longer
than the oral record.
I would go back to one thing Austin said. I mean, I think all of these ideas are sort of very constructive if you start from the premise that the Commission wants a period of repose, and I think that sort of here is the question too. I mean, a lot of what goes on that creates issues for, during the sunshine period is, commissioners call up people and say, on Wednesday, here's where it's heading. I want to ask you what you think. And, if they want that, then it creates problems. You mentioned, well, then people can request to have the commissioners ask, and it sort of gets to become a sliding scale. So, I mean, the core thing, it seems to me, is what does the commission want? I think the premise was 20 years ago it was sort of helpful to rational decision-making to just say at some point it all stops and sort of everyone is thinking internally and discussing things internally. And the real question to me is, do the commissioners want that? And if the commissioners want it, then I think, the rules work pretty well, and you can have various sort of, tweaks to the rules and maybe focus just on, prohibiting oral and not written. But to me, the fundamental question is, what does the commission want? Because I think with the sunshine period, it's always been tension between sort of OGC has a concept of what the record should look like, and so there are rules to sort of help with that, but it's not how the commissioners want to act necessarily.
I believe that the problem of this soliciting communications during the sunshine period is huge and is one of the very biggest problems the Commission faces in transparency. Therefore, I think you have to either raise the bridge or lower the river. Either you bar all oral communications during the sunshine period, or if you permit them, you have to permit them all.
With disclosure.
With disclosure.
Yeah, and I think what the Commission actually wants can inform your decision of which of those to do. But also in terms of your question about whether you should extend the ignore the sunshine period for electronic while not for others. Part of the problem with the current sunshine period setup is that there will always be disparities in how much access different parties have. But the way the current sunshine period is set up, it amplifies those disparities. People with access can go through Congress. People with access can solicit invitations. And I think the sort of thing where you limit it to electronic filings is another way that it would amplify those disparities, and that's what we want to avoid. So that would return to Andy's point, which is raise the bridge or lower the river. So we can make that decision based on what the Commission wants, but one or the other should happen.
I think you should get rid of it. The main reason being that it, for all the complexity, and it makes things unfair. So, I don't know if you all remember, but after 9/11, after the anthrax scare, actually, getting mail into the commission became a really difficult issue. So what about that, ordinary person who just wants to write a letter and get the commissioners to hear him, from the hometown or something like that, who might or might not have access or might not be aware of ECFS. So I think, getting actual communications to the commission should be open to all formats, as many formats as possible. The commissioners are going to decide the relevancy. It's not really up to the other folks. The second issue is it's an arbitrary deadline, right? The commission decides that it's going to put a bunch of items on the meeting agenda, and sometimes it takes them off, sometimes it puts them on, it puts additional things on. The date is essentially unknown for the most part until it's announced. So I think it's an arbitrary artifact, and I think it really came out of this concept of repose came out of the old days when we didn't have computers and word processors and things like that, and people had to scramble to put that record in place. It took an enormous amount of effort internally to do that. I don't think we have as much of a problem today. So I think the best thing to do is get rid of the sunshine, let people decide whether they want to have meetings or not, and sort of suffer the consequences one way or the other.
Yeah, and one minor point I just wanted to add, if the purpose is truly repose, then leaving the electronic record open kind of eliminates that purpose. If something is submitted electronically which is relevant, then the commission needs to read it and they don't get reposed. And if it's not relevant, then why did we allow it to be submitted in the first place?
And as Amy said, if the commissioners want repose, they can say no to a meeting anytime they want. I mean, it may be difficult politically, but they can't do it.
It is difficult politically, but I think the fundamental key here is the fairness element. We've kind of gone off on up and down on different topics in this, but in terms of whatever access there is during that period, I think it needs to be across the board that anyone can get it. There's a fundamental fairness that has to go with this. The blogger exception bothers me in the sense that it does sort of create some disparity.
To that end, another little piece, but I've heard a lot of disagreement, but I think earlier I heard directly and thematically I believe we may have consensus on this point, that to the extent that contacts occur during the sunshine period, they need to be promptly and pervasively reported. And is there, maybe we just go around with a yes/no, maybe starting with Amy. Should there be a rule for reporting ex parte contacts during the sunshine period that requires electronic submission of the ex parte notice and sets a very short deadline for doing that?
Yes.
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 Mandatory electronic filing, yes.
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 Is there a but?
Someone earlier proposed the idea of during the sunshine period, even if commission don't normally file, that would be an appropriate time for them to get involved. I like that idea.
I think yes, with the commission taking on the responsibility, for example, for pro se folks and letting them know we will file it, send us the letter, fax it to us.
Some mechanism.
And
I think the reference center is probably set up to allow people to use a computer to do something like that, or should be.
I think setting up a mechanism so that people can actually transmit it and make sure that it's actually entered into the record. Now, all of this is driven. So one of the things you have with paper filings is it's really not an issue of it not being delivered to the commission. It just takes
3 or 4 days.
3 or 4 days, and having run an informal complaints group within the commission, I know it's people send it to you on napkins and stuff like that. So, but I think there, if the staff is relying on the information, they should also sort of relay and say, hey, I know it might be difficult to get the information, so do you need any help? That would go a long way.
Absolutely. Like I notice in the Daily Digest, you see the list of ex parte filings, and it'd be nice to have a quick link to it or something. I know that even when I see that, I go to the record and it's not necessarily in there yet. So maybe it's through ECFS, 2.0 or whatever it is that the actual form you submit instead of the traditional normal paper filings, you submit the actual ex parte in the little box that they give you, and that is actually immediately available.
I think the key theme that I'm hearing, and I certainly feel, is that whether you keep the sunshine period or get rid of the sunshine period, that you make access available in a non-discriminatory manner as much as you possibly can, and access to information like ex partes, and access by whatever means you're trying to communicate with the commission, whether it's blogs or written meetings or written filings or oral meetings. I think that's the key point.
I think one maybe practical suggestion may be that you sort of self-select people that want to do everything electronically. So, if Chris wants to says, look, I'm going to be an electronic filer, sort of like the SEC. I'm going to file under Edgar as an electronic filer. Then you sort of have that obligation. If you're not, then you have other mechanisms to provide it, and that the commission is aware that you as a filer don't fall into that group.
Okay, we're going to change course a little bit.
I apologize. I have to go upstairs. Thank you.
Going to file that?
Yeah, I'm an ex parte, I promise.
Right.
Thank you, Jane.
So some have asked whether there should be a rule that discloses the kind of the real party in interest or discloses people who have made monetary contributions towards the preparation of the brief or presentation or comment, whether kind of who's the parent company. At the Federal Trade Commission, there was, you would need to report an advertising, disclosure of material connections. Do you think that is a problem or something that we need to look at all, Andy?
I think it's an occasional problem, and I think it would be salutary to require some sort of disclosure of that kind. However, it does get tricky. I'm disappointed Jane had to leave because this is a trade association problem as well as a problem for us. We often come into the commission, as I am here today, speaking generically on behalf of a constituency, but not representing anyone in particular. And identifying a real party in interest in that kind of situation, or identifying a real party in interest for a trade association, could get very difficult and cause problems. But the simpler case, and in the court rules, that's recognized, and
right. And the associations
right.
do not.
So that has to be teased out. But there have been occasional abuses, and certainly the principle: if somebody is being paid to make a representation on behalf of somebody, that real party should be identified.
I'm not sure that it's a big issue in the sense of if we're talking about permit but disclosed proceedings or rulemaking types of proceedings where anybody, there's not the standing issue, right? So in the courts, you want to make sure that they're standing, but I'm not sure in these kind of proceedings it matters as much as the fact that a certain position has been filed and taken and disclosed. So if the other parts of the ex parte rules are working, I'm not sure that this is necessary.
Okay.
I would just add to that. I mean, I agree with both those statements. It is something that should be, or I would say I agree with Andy that it's something that should be added, but in practice it has not been a huge problem, except that I think the place where it is a problem is John Q. Public, because while I may know that this person is really representing this organization, random people in the public may not know that, and that's something that that's information that they should have access to.
Okay.
Yeah, sure. On new media, since we just have a couple of minutes, in a couple of recent dockets, we've tried to experiment with including in the record things like blogs, and I just want to get people's reactions to what they see as the benefits and the pitfalls of doing that. And just to give one example, that we were recently criticized by one party for giving blogs access, as Austin mentioned, during the sunshine period when not everyone had immediate access to the internet. There are also questions of how to deal with filings on a blog that may be anonymous, and just whatever thoughts people might have on the new media issue. And why don't you start off, Jeff, given that your organization deals a lot with electronic government type issues?
Absolutely, and I will say that this is something we're still discussing internally, and it's a very complex problem. But I think Chris hit on a really good point, which is that I think the Commission needs to consider very carefully what things it does that are should be part of the record, or should be part of the record automatically, and should not. So the Commission's function does not only include record making. The Commission includes functions of promoting dialogue, promoting conversation, and the blog serves that function in a very real way. So that doesn't necessarily mean that everything that happens on the blog should be part of the record. And if the Commission decided to take that approach, you could leave the blog open indefinitely with the understanding that if you want something you say on there to be part of the record, either through an automated system like Chris suggested, or through a manual system where you have to go over to ECFS and type in, copy and paste your post if you want it to be a comment in the record. Whereas under normal circumstances, your blog post is a communication, kind of like your letter to the editor of the Wall Street Journal, but is not in the record. But I think this is a very quickly evolving question, and the Commission needs to consider these things on a case-by-case basis and look at these new technologies, these new forms of communication as they happen, as the Commission offers them, and decide whether they're really what function they're serving.
Does that create a problem of the Commission then selectively culling through the off-record comments and including into the record those with which it agrees, those that support the conclusion, but not the others?
I mean, the way I was envisioning this, the blog posts are not part of the record any more than a letter to the editor of the Wall Street Journal, a post on my own personal blog, my own webpage, the homepage of an interested party. They're not part of the record, and the Commission can include them in any way that they normally could. So someone could file that thing and make it a part of the record, but the Commission can't rely on something that is purely on the blog and has never been submitted in another fashion to the record.
There's already, the Commission makes exceptions prior to this blog thing about informal comments, right? Sort of people that go to proceeding page and type in a brief comment, I support X, Y, Z, and I'm a bit chagrined that this sort of has blown up because that's been around for a while, which is, the issue here is how does the Commission treat these informal comments is, I think, the core issue, as opposed to whether it's a blog or it's an email or some other format. I think I just would caution the Commission not to give preference to one communications medium by granting a waiver in a particular proceeding or whatever. I think it's either all or nothing in terms of communications media because no matter what we do, there's still 5% of the population that doesn't have phones. So that's the kind of thing we have to deal with.
The one thing I would say, though, is you have to start somewhere. And absolutely, the FCC is working extraordinarily hard, as are a lot of companies out there, to get broadband to everybody, and to not rely on some of those communications in some organized fashion, I would add. Be it drop-down menus in a blog fashion. You're actually discussing these issues in FCC docket 96, 86, or whatever. There's practical ways to do it electronically, but I don't want to, exclude those people that have access to actually be part of the dialogue.
I think the issue here is, I wanted to point out one thing. Please don't do anonymous postings. I think that's absolutely a terrible idea. You can have people can do anonymous postings, but people should tell you who they are, what to what their personal, where they are, so you can actually track them down to the extent that you rely on the information. You're able to identify and figure out where Jeff is and ask him a question. But I'm not trying to say exclude blogs. I think what we need is clarity on how you treat these sort of informal comments that come in that don't sort of have the normal, lawyer headings and all that kind of stuff.
And I think to include it in the record, as Jeff and I have been discussing, the blog posting that the poster wants to include in the record kind of has to do a blog plus. You'd hit a button, say, on the blog, and it would pull up ECFS so that the required field's in ECFS in order to put something in the record. So that there's a distinction between putting something on the record and expressing your ideas, where one is just an outlet of your First Amendment rights and your expression, whereas the other is you want this considered by the commission and you have your name attached to it and your party. And so I think having something to push it into the record allows for the expression outlet and then also allows you to put the proper formality into it.
The tension, and I don't know the answer, but just the tension seems to me how the commission and the staff is going to use it, because to the extent the commission staff is going to say, we're going to follow the blogs closely, we're going to, these blogs are going to help inform our thinking on the proceeding, then it's difficult to say, and we'll choose which of them we're going to put in the record. I mean, it just creates some tension. I don't know the answer, but it's a hard issue.
And that's the tension with old media as well. For instance, I think all the commissioners and commission staff, if not all, get Com Daily, and so you can put the ads in Com Daily during, say, a sunshine period and influence that way. I mean, there are always those intentions,
the net neutrality NPRM says that is a formal way to file comments. So, I mean, at least for that proceeding, the commission has said everything is in the record. Interesting.
In which case, the blog should actually have more identifiers to it. Right now, you can file as a guest, you can file anonymously, you can have some sort of strange screen name that would never be identified to you.
And I think that's why I say the commission needs to carefully consider what the purpose of these different services it's offering is. If you want the blog to be a record producing, if you want it to serve a record producing function, then you should ensure that it has the same features as the other record producing functions, including being able to find the person who filed it and ask follow-up questions. There's definitely value to having a blog which allows anonymous postings. Having people be able to communicate anonymously is a very important feature, but that may not be appropriate for inclusion in the record. In a year, the answer to the question of whether the blog is appropriate for the record may change. Maybe in a year, you'll have individual message boards for each proceeding, and that will be part of the record, but the blog will be a purely informal discussion point. So I don't actually have a conclusion as to how the blog should be applied now or in a year, but I think it's very important that the things that go into the record have the features you've decided are important to the record, and not be treated differently from other forms of media and sort of, amplify the digital divide that it's part of the commission's mission to close.
I think I'm going to cut off the discussion there. It's noon now, and I'm with your indulgence, I'm going to take maybe 4 more minutes. First, we asked for questions from the audience, and there were a couple of questions for the panels, which I think we touched on and answered at least indirectly. There were also several questions for the three of us, really, and I'm just going to ask Joel very quickly to talk about those.
One question was, what was the status of the ex parte NPRM that was circulated earlier this year? And my expectation is, and obviously this will depend on discussions with the commissioner's offices, would be that based on the input that we've gotten today, that there will probably be a revised version of that NPRM, but the exact details of what changes we would be making or staff would be proposing, we will need to have further discussions based on the conversations today. There was a question about whether in 1995, when the Commission proposed ex parte rules, that it proposed a requirement that the ex parte summary highlight, quote, unquote, the positions taken, and then we adopted a somewhat different standard when we actually adopted the rules a couple of years later. I think as a general matter, the standard that we adopted that includes a requirement for a filing of all new facts or arguments that weren't previously in the record largely encompasses the standard of the positions taken, perhaps with a bit more detail. But again, that's something that as we go back and take a look at the rules, we can take another look at, particularly in the context of whether or not we should be requiring a filing for all ex parte meetings rather than simply ones that had new data or arguments. And then there was a question in terms of whether the Commission has taken ex parte enforcement actions and issued sanctions, and if we have done so on a public basis. And the answer is that we have done so in cases where the Commission thought the violations were especially serious. And the other thing I should mention here is that aside from ex parte reform, another part of the Commission's reform agenda is to increase the number of docketed proceedings, which, as that happens, both the pleadings and the Commission's decisions, as a matter of course, would be electronically available as opposed to someone now having to come and ask for them.
Thanks, Joel.
Yeah, I was just going to say ECFS now gives us the capability to handle a lot more proceedings. And so where we kind of narrowly define things as docketed proceedings and therefore part of the electronic system, we are working to expand what we can include in ECFS so that more proceedings will be available electronically.
Right, and one of the reasons for that is someone recently told me that before the anthrax events in 2001, approximately 80% of filings came into the Commission in paper form and then actually had to be manually scanned into ECFS. Now the vast majority come in electronically, so that makes it much less of a resource issue going forward.
I'm very solicitous of John's heartburn concern, and I personally can't stand leaving court wishing I'd said one more thing. So if there's anyone who would like to say something before we adjourn, this is your chance.
This is my mailbox.
Anyone?
I think two issues. I think one is we've made a lot of distinction about agenda meetings. And I think we also need to look into sort of non-agenda items and sort of how the ex parte rules play with them. And I think the second thing is I would ask, to the extent that you're looking at changing the ex parte rules, some of the data that you need to look at is how the Commission has handled decisions that have a very strict timeline, and sort of whether that process has really facilitated a much more fulsome discussion. 271 proceedings, the transfer and control of licenses. 1996 had the 1996 Act had a whole bunch of deadlines. Forbearance petition is another issue which might cut both ways. And then the Omnibus Broadband Initiative itself, I think, is very instructive about what people are willing to put forth into the record and the level of disclosure. So those are my two Maylox moments. Thank you.
Anyone else?
I would just say, again, accessibility, the technological advances to allow, for quick turnaround of some of these filings would be very instructive, and I think instructive for the Commission staff as well, if we're going to talk about response from them and asking for additional information in a timely fashion. That is a critical issue that needs to be addressed.
I think. Yep.
I would just point out that I think sort of creating a new enforcement regime is probably going to be counterproductive. With the David's cottage industry piece, I think there's just a lot of focus. The focus would shift to process rather than the substance. And the point is for the Commission to make decisions based on the best information available. And I think that's where the focus should stay. I think Commission staff can change the practices informally, but very effectively.
I think I'll let that be. No? This is the last word.
Just to continue to emphasize, maximize the use of the electronic systems, be it in docketed proceedings, non-docketed application proceedings. If everything's coming to the Commission except for a very few, very, very small amount of documents, that's the way it should be. And in fact, every document should be able to come into the Commission electronically, and there's still some holes to fill there.
Great. So. Thank you to the panels. I think this was a tremendous discussion. I know it will be very helpful for me, and I'm sure for Joel and Mary Beth, and I hope to those in the audience it was interesting and informative to you as well. So thank you all very much.